If you are 72 years old and you have lived inside the same home for over 3 decades, you paid off every last dollar of that mortgage, you raised your children within those walls, and every single corner of every room holds a memory that belongs to your life, then what I am about to share with you may be the most important information you encounter this entire year. Let me paint a picture for you. One completely ordinary morning, you suffer a stroke, you survive. But you cannot speak. You cannot write your own name. You are incapable of making a single decision on your own behalf. Your daughter rushes to the bank to make sure your property taxes get paid before the deadline passes. She steps up to the counter. She tells them your name, and the person standing on the other side of that counter looks directly at her and says, "I am sorry. You have no legal authority over this account. Your daughter cannot pay your bills. She cannot access your accounts. She cannot sell your home, she cannot refinance it, and she cannot even coordinate basic repairs to keep it maintained. Everything is completely locked, and the bills do not stop coming. This is not something that only happens to other families. According to the Consumer Financial Protection Bureau, this exact situation plays out for families all across America every single day, because 5 straightforward legal documents were never signed, never completed, never put into place. My name is Ralph, and here at RightGuard USA, we exist to make sure this never happens to you. I work as a senior policy analyst with a specialization in retirement finance, Social Security regulations, and the legal protections that exist specifically for Americans over the age of 60. Today, I am going to walk you through the 5 most critical documents every homeowner over 60 must have secured before a crisis ever arrives. These are not personal opinions or things I read on a random website. Every piece of information I am about to share with you comes directly from official government sources: the Consumer Financial Protection Bureau, Medicare.gov, the IRS, the Social Security Administration, and verified research published by AARP. And here is the reason I need you to stay with me through every minute of this video. There is a concealed tax trap buried inside document number 5 that can cost your children hundreds of thousands of dollars in capital gains taxes. It comes down entirely to one single decision you make about your home while you are still living and still capable of making it. Most people have never been told this trap exists. By the time this video is finished, you will know exactly what it is and precisely how to protect your family from it. Let us get started. I want to tell you about a man named Robert. Robert was 67 years old, a retired electrician living in Ohio. He owned his home outright with no mortgage remaining. He had a modest pension, his monthly Social Security payment, and a small savings account he had been quietly building throughout his working years. Robert thought of himself as a responsible man who had his affairs in order. He had sat down with his 2 adult children, David and Karen, and explained exactly what he wanted to happen when he was no longer around. The house would go to Karen because she lived close by and could properly care for it. David would receive the savings account. It was straightforward. It was fair. He laid all of this out over Thanksgiving dinner in 2023. Everyone listened, everyone agreed, but Robert never committed a single word of any of it to paper. He never executed a will. He never filed a power of attorney. He never set up a transfer on death deed. He assumed that because his children already knew what he intended, everything would simply fall into place naturally. Then in early 2025, Robert suffered a serious fall. He struck his head and sustained a brain bleed that left him completely unable to make decisions for himself. Karen went to his bank to cover the property taxes. She was turned away at the door. She contacted the Social Security Administration to manage his incoming benefit payments. They informed her she carried no legal authority to do so. She attempted to arrange necessary repairs to the home so that Robert would have a safe place to return to after rehabilitation, and discovered she was unable to sign any contracts on his behalf. Meanwhile, David retained an attorney and filed a petition with the court seeking formal guardianship. And just like that, Karen and David were no longer working together. The court took control of the situation. Legal fees began piling up. Robert's home sat vacant for 11 months. Property taxes went unpaid during that time. A lien was placed against the property. 11 months. No legal authority, no plan in place. A home that nearly slipped away entirely. Every single piece of that nightmare was entirely preventable if Robert had filed 5 documents. Let me show you what those documents are. Document number 1, the Durable Financial Power of Attorney. This is the single most important legal document for any homeowner who has crossed the age of 60. A durable financial power of attorney gives someone you trust, a person the law calls your agent, the legal standing to make financial decisions on your behalf in the event you become incapacitated. That covers paying your mortgage, managing your bank accounts, handling your property tax obligations, and even selling your home if circumstances make that necessary. Pay very close attention to the word durable here. According to the Consumer Financial Protection Bureau, a standard power of attorney actually terminates the moment you become incapacitated. That is the exact moment when you need it functioning most. A durable power of attorney remains fully active even after you have lost the capacity to manage your own affairs. Here is the misconception that trips people up constantly. The vast majority of seniors believe that a spouse or adult child has the automatic legal right to step in and handle their finances if something goes wrong. The Consumer Financial Protection Bureau is completely clear on this. That belief is simply incorrect. Without a properly executed durable power of attorney, no family member holds any legal authority to act on your behalf. Not your husband, not your wife, not your son or daughter. Without it, your family has only one path available: filing a petition with the court for guardianship or conservatorship. The CFPB describes that process as lengthy, expensive, and very public. AARP has documented that conservatorship proceedings regularly generate serious conflict within families, produce competing petitions from different relatives, and ultimately result in a court, not your loved ones, making the decisions that govern your daily life. One additional point worth emphasizing. The Social Security Administration now offers something called the Advanced Designation of Representative Payee. This allows you to identify up to 3 people who could step in to manage your Social Security benefits if you ever become unable to handle them yourself. You can complete this designation right now through your My Social Security account at ssa.gov. I want to strongly encourage you to do that today, not at some future point, but today before anything else comes up. Document number 2. A last will and testament with specific provisions for your home. Now let us address your will. Not just a general will, one that directly and specifically addresses what is going to happen to your home. According to the Consumer Financial Protection Bureau's official guide for older Americans, a will is the legal instrument that establishes your intentions for your property at the time of your passing, and that absolutely includes your home. Here is where the deepest misunderstanding lives. A significant number of seniors genuinely believe that expressing their wishes verbally to family members carries legal weight. It does not. Without a valid written will bearing your signature, your home passes according to your state's intestacy laws. That means the state, not you, determines who receives your property. And the formula your state applies may direct your home to people you never had any intention of leaving it to. AARP states this plainly. Without a will, the outcome is governed by state law and probate courts, which creates unnecessary delays and financial expense. This can produce what AARP refers to as tangled titles, situations where the person living in the home is not recognized as its legal owner. That individual cannot sell the property, they cannot refinance it, they cannot obtain proper insurance. In certain circumstances, they cannot legally authorize even basic maintenance repairs, and the financial damage is real. AARP estimates that navigating probate without a will can consume over a full year and cost upward of 3% of the estate's total value. On a home and estate valued at $1 million, your heirs could lose more than $30,000 to probate costs alone. If you are over 60 and you own your home, you need a will. And if you already have one, pull it out and look at the date it was signed. If it was drafted before a major life change, a divorce, the passing of a family member, the birth of grandchildren, it very likely needs to be updated to reflect your current circumstances. Free legal assistance is available to people over 60 through the Elder Care Locator. That number is 1-800-677-1116. Document number 3, a transfer on death deed or a revocable living trust. This is the document most seniors have genuinely never come across, and it may be the most powerful one on this entire list. A transfer on death deed, commonly called a TOD deed, is a legal document specifying that when you pass away, your home transfers directly to the person you have designated. No probate, no courtroom proceedings, no extended waiting period. According to the Consumer Financial Protection Bureau, it is simpler to create and less costly to establish than a trust. As of 2026, approximately 30 states along with the District of Columbia and the U.S. Virgin Islands permit transfer on death deeds. You file it with your local recorder of deeds office. You retain complete control of your home for the remainder of your life and can modify or cancel the deed at any point. If your state does not permit transfer on death deeds, the appropriate alternative is a revocable living trust. According to consumerfinance.gov, a living trust allows you to transfer your home into a legal structure that you personally control throughout your lifetime. You function as your own trustee. Upon your passing or incapacitation, a successor trustee you have already designated steps in, with no probate process required whatsoever. But here is a critical error that catches many people who have already taken this step. A significant number of people create a living trust and assume the work is complete. It is not. The Consumer Financial Protection Bureau is very specific about this. A living trust accomplishes absolutely nothing until property is physically transferred into it. That means you must retitle your home in the name of the trust. If you neglect that step, your home still travels through probate, even though you paid an attorney to establish the trust in the first place. The CFPB also issues a clear caution. Trusts are sometimes marketed by dishonest individuals and companies that specifically target seniors. If anyone approaches you without being asked, offering to create a trust on your behalf, verify their professional credentials carefully and consult an independent attorney before taking any action. One more element that is absolutely essential to understand. According to Medicaid.gov, state Medicaid programs are required under federal law to pursue recovery of payments from the estates of individuals aged 55 and older for nursing facility and home care services that were provided. States may even place liens against your home during your lifetime if you are permanently institutionalized. However, and this exception carries enormous significance, states are prohibited from pursuing estate recovery if you are survived by a spouse, a child under the age of 21, or a child who is blind or permanently disabled regardless of age. Understanding these rules thoroughly before making any decisions about transferring your home is not optional. It is absolutely essential. Document number 4. An Advanced Healthcare Directive. This is the document that protects your body and ensures your medical wishes are honored, not just your bank account and financial assets. According to Medicare.gov, an Advanced Healthcare Directive contains 2 distinct components. The first is a healthcare proxy, sometimes referred to as a durable power of attorney for healthcare. This designates a person you trust to make medical decisions on your behalf if you are no longer able to communicate those decisions yourself. The second component is a living will. This document records which medical treatments and interventions you want, or specifically do not want, if your life is in serious jeopardy. That includes your preferences regarding dialysis, mechanical ventilation, resuscitation, feeding tubes, and decisions about organ or tissue donation. Here is a misunderstanding that costs people enormously. Many seniors assume their financial power of attorney automatically extends to cover medical decision-making as well. It does not. The Consumer Financial Protection Bureau draws this distinction with complete clarity. A financial power of attorney and a healthcare directive are two entirely separate legal documents serving two entirely different functions. You need both of them. And here is a second mistake that renders the directive ineffective even after it has been properly completed. People sign the document and then store it in a drawer without telling anyone where it is located. If no one can locate your directive during a medical emergency, it offers you no protection whatsoever. You must provide copies to your physician, your hospital, your designated healthcare proxy, and at least one additional trusted family member who is likely to be present in a crisis. There is meaningful good news here. Medicare covers advanced care planning conversations at no cost to you when that discussion takes place during your annual wellness visit. The next time you attend that yearly appointment, raise this topic directly with your doctor and ask for their assistance in formally documenting your wishes. You are completely entitled to do so. Medicare.gov states explicitly that you have the right to execute your plans as you have chosen without facing discrimination of any kind. AARP has documented that the absence of a healthcare directive is one of the primary catalysts for conservatorship proceedings that fracture families permanently. Do not leave your family in that position. Document number 5. Your Homestead Exemption and Senior Property Tax Exemption application. This is the document that saves you real money every single year, and it contains the hidden tax trap I promised to reveal at the opening of this video. Most states and many local governments offer homestead exemptions or senior property tax relief programs. These programs reduce the assessed taxable value of your home, which directly reduces your annual property tax obligation. Some states go a step further and offer tax freeze programs that place a hard ceiling on how much your property taxes can increase from one year to the next. Here is what catches people entirely off guard. These exemptions do not apply to you automatically. AARP is completely direct about this. You must submit a formal application to your local county assessor or tax authority. And in many jurisdictions, that application must be renewed each year or on a regular periodic schedule. AARP quotes a subject matter expert who puts it in plain terms. Anyone can forget to complete the annual renewal, particularly older adults who are managing large volumes of incoming correspondence. Miss the filing deadline, and you pay the full unexempted rate. Accumulated over 10 or 20 years of retirement, that oversight can add up to tens of thousands of dollars in entirely unnecessary expense. On the federal level, the IRS now offers Form 1040-SR, a tax return designed specifically for seniors with larger, more legible print. And beginning with the 2025 tax year, there is a new enhanced standard deduction available to taxpayers who are 65 years of age and older. According to IRS Publication 554, if you are considering selling your primary residence, you may be eligible to exclude up to $250,000 in capital gains from the transaction, $500,000 for married couples filing jointly, provided the home served as your primary residence for at least 2 of the previous 5 years. That guidance comes directly from IRS Publication 523. Now, here is the hidden tax trap I flagged at the very beginning of this video. This is the one with the greatest potential financial consequences for your family, and it is the one almost nobody talks about. If you deed your home to your child as a gift during your lifetime, your child inherits your original cost basis in the property. Let me translate that into real numbers. Suppose you purchased your home 40 years ago for $50,000. That home is worth $400,000 today. If you gift it to your son, his cost basis is $50,000. When he eventually sells that home, he will owe capital gains tax on $350,000 of recognized gain. But if you retain ownership of the home and he inherits it after your passing, something fundamentally different occurs. Under IRS Section 1014, the cost basis steps up to the fair market value of the property on the date of your death. His basis becomes $400,000. If he sells it for $400,000, his capital gains tax liability is zero, not reduced. Zero. That single decision, whether to gift the property during your lifetime or allow it to pass through inheritance, could represent the difference between your child protecting their financial future and surrendering a massive portion of it to the federal government. This information comes directly from IRS Publication 551 and the IRS Gifts and Inheritances FAQ. Please consult a qualified tax professional before transferring your home to anyone under any circumstances. You now have all 5 documents clearly in front of you. But knowledge that leads to no action changes absolutely nothing. So here are 3 concrete steps I want you to take this week. Not sometime next month, not at some vague future point. This week. Step 1. Gather your 5 documents and identify exactly where the gaps are. Sit down at your kitchen table with a pen and a sheet of paper. Go through the complete list. Place a checkmark next to every document you already have properly in place. Circle every one that is missing or incomplete. The list is as follows: a durable financial power of attorney, a last will and testament that includes specific instructions for your home, a transfer on death deed, or a revocable living trust with your property properly titled into it, an advanced healthcare directive that includes both a living will and a designated healthcare proxy, and your homestead or senior property tax exemption application with its renewal status confirmed. If even a single item on that list is missing, you have a gap. And gaps are precisely what cost families their homes, their savings, and the peace of mind they spent a lifetime working to build. For any documents you need help creating, contact the Elder Care Locator at 1-800-677-11116. This is a free government-funded service available to every American over the age of 60. They will connect you at no cost with qualified legal assistance in your local area. That number one more time, 1-800-677-1116. Step 2. Place your documents in the hands of the people who actually need them. Completing a document and placing it in a drawer is not a plan. It is a starting point. Your durable power of attorney needs to be formally on file with your bank and every financial institution you work with before any emergency situation develops. The Consumer Financial Protection Bureau specifically warns that many banks will decline to honor a power of attorney document they have never previously reviewed and accepted. Do not discover that limitation for the first time in the middle of a crisis. Your advanced healthcare directive must be physically in the possession of your physician, your hospital of record, your designated healthcare proxy, and at least one additional trusted family member who is likely to be reachable in an emergency. And while you are taking these steps, log into your My Social Security account at ssa.gov and complete your advanced designation of representative payee. Identify up to 3 individuals you trust without reservation. This costs nothing, it takes only a few minutes, and it has the potential to prevent an enormous amount of chaos, conflict, and heartbreak for your family. Step 3. Review and update everything on a regular annual basis. Life changes over time. Relationships shift. Laws are revised and updated. The person you named as your agent 5 years ago may no longer be the right choice today. A will written before a divorce may direct your home to someone you have no intention of leaving it to. Choose one specific date each year, perhaps your birthday, perhaps January 1st, and treat it as your annual personal review appointment. Confirm that every document still accurately reflects your current wishes and circumstances. Verify that the appropriate people still hold current copies. Confirm that your property tax exemption has been properly renewed for the coming year. That single annual habit may turn out to be the most consequential thing you do each year to protect everything you have built over a lifetime. Before I let you go, I want to say something that I mean genuinely. Everything covered in this video has the real potential to change the trajectory of your retirement. It can protect the home you worked decades to own. It can spare your family from courtroom proceedings, unexpected tax burdens, and financial devastation that should never have been allowed to happen. But here is the reality you need to sit with honestly. The government is not going to mail you a reminder to file these documents. There is no alert that appears on your phone when an important law changes. And depending on a social media algorithm to surface the right information at precisely the right moment is not a protection strategy you can rely on. Right Guard USA exists to make sure you are never caught without the information you need. We send real-time alerts whenever there is a meaningful change to Social Security policy, Medicare rules, pension regulations, banking laws, insurance standards, or any financial matter that directly affects seniors. No irrelevant messages, no advertising, only clear, verified, timely information delivered straight to you so that you are always ahead of what is coming your way. Click the link in the description right now. Subscribe to the Right Guard USA channel, download your complimentary protection guide, and share this video with someone you care about who owns their home and is over the age of 60. Because the 5 documents we covered today carry only one condition for them to work. They must be in place before the crisis arrives, not after it does. I am Ralph. Thank you sincerely for spending this time with me here at Right Guard USA today. I will see you in the next video. Stay safe, stay informed, and protect every single thing you have spent your entire life building.